Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh, and we have so much to go over today, which is why I'm up early this morning. If you were with me, last night, when I was with Omar, the Tilted Lawyer, at the end of that stream, no, you weren't. And if you were there at all during the stream, then you know that at least 3 filings got dropped on the docket last night at a late hour. First, we had that letter from Ryan Reynolds and Blake Lively to the judge, which I'll be reading in a separate video that'll come out in a couple hours. But I'm up early this morning because Stephanie Jones has submitted her motions to dismiss the counterclaims by Jennifer Abel, and then a separate document in her motion to dismiss the counterclaims by the Wayfarer parties, which includes Justin Baldoni. So we're going to go over that. I'm telling you right now, I'm not going to read them word for word because, well, this is a horrible hour, and and I have work in a couple hours, so I can't take too long on that. I also want to say there's a video I'm working on with your voice clips that a lot of you guys sent in last night. Because so much happened between last night and now, and I have so much to go over, I'm thinking I'm probably going to be posting that on either Sunday night or Monday morning instead, because that way it'll give me more time to get more of your messages in there, to edit it in a way that's not going to be, sloppy and put together quickly. So we'll do that. I'll give people like another 30 seconds or so to filter in here, and then I will get started, okay? Give me 1 second here. Hey, Bren, what's up? Hey, Kirsty. Okay. We're going to go over the one to Abel's claims first. How about that? We'll zoom in a little bit. And remember, this is the lady who has the website against her, or like that she was complaining about in her lawsuit, Stephanie Jones Lies or whatever. And she's trying to sue those anonymous people who made the website. Yeah. Okay. She's totally not insane. All right. Abel alleges no extreme or outrageous conduct. That's hilarious. I can already tell this is going to be ridiculous. Okay. Sorry, I'm just skipping over the table of contents here. I did not get a chance to read entirely through these last night because I was so tired already, but... Okay. Preliminary statement. And then this, she's including a text message here from her to Jennifer Abel. It says, "No one senior behaves like this. It's reactionary, dramatic, and immature. Sad." Okay. I can tell this is going to be normal. Okay. In her soap opera script masquerading as counterclaims, Jennifer Abel follows a reactionary, dramatic, and immature, but sadly familiar playbook of filing legally faulty and baseless claims as a vehicle for her self-serving public narrative. Oh boy. Abel's counterclaims are nothing but a masterclass in dissembling a diversion, a nothing is my fault retort that seeks to avoid accountability for her unethical and unlawful actions revealed in Jonesworks' complaint. Abel has no response for her duplicitous campaign to ruin Jones' reputation and steal Jonesworks' clients. And then here's a text message from Melissa Nathan to Jennifer Abel. It says, "I know, and once you're gone, we'll be on accounts together and make really good money and be happy." That actually is not the flex that Stephanie Jones might think it is, because that could obviously be in the context of like, hey, I know you're stressed out, but it's going to be better once you're on your own and you get out of that job, which you're obviously not happy at, but all right. Instead, she resorts to hyperbolic fantasy. Hyperbolic fantasy. Title of my autobiography. Seeking to rewrite history with a series of falsities, attempted character assassinations of Jones, and defamatory accusations about supposed leaks when, in reality, There was no leak. That's yet to be seen. The text messages she wrote on a company phone were produced by the company in response to a lawfully delivered subpoena. Okay. But the thing is, did you actually tell people about it? Like, did you tell the other side about it before they got the subpoena? Because that's certainly what it seems like. Given, like, right after she was let go, which is, questionable given she was, like, leaving already, you then, or sorry, not you then, but, like, Leslie Sloan had then texted, I think it was Nathan, and said, basically, I've seen what you did, like, right after. So, yeah, there's definitely some questionable stuff there, even if there is a valid subpoena. It doesn't mean that you didn't do anything wrong before that. Okay. The text messages she wrote on a company phone were produced by the company in response to a lawfully delivered subpoena. Try as she might, Abel cannot distract from the reality that these text messages do not in fact reveal Abel's own private and personal information, but instead reveal a vicious campaign to bury and destroy Blake Lively on behalf of Justin Baldoni and Wayfarer Studios and go to war with Jones. And that these are text messages that she has now been forced to admit, in this case, that she and Nathan wrote. In other words, Abel is doing exactly what she intended all along and has now admitted in this case, go out of Jones Works with a bang. And I'll admit, I've said this before, the messages that she sent on the phone, which was a company phone, but it did come from her personal phone number, which was attached to the phone. It was not great to send those things from that phone, knowing that she had a tumultuous relationship with Stephanie Jones towards the end, but nobody deserves this, okay? I'll say that. Notwithstanding Abel's hand-waving and false denials of wrongdoing, what is most revealing is what Abel now admits. Despite trying to distance herself from the Business Insider takedown piece against Jones, Abel now admits she repeatedly spoke with Business Insider reporter Katie Warren between July 30th and August 12th. Admits that I've never seen her admit that, so... Admits that she went out of her way to ensure the article omitted the positive statement Baldoni and Wayfarer had previously written in support of Jones. Admits that she exchanged messages with Nathan the day before the article was published, including boasting with Nathan about the harmful effects it would have. And even admits that Business Insider writer Warren thanked her for helping with a hit piece once it was published. So this is from Melissa Nathan to Jennifer Abel. It says, oh, yeah, right. So that's actually not what's going on here. So they were sarcastically joking with each other. And I don't know if this was even before or after the article came out, or maybe they're just joking about it because she was made aware of the article because somebody from Business Insider asked her for a quote or something. It says, Stephanie, are you aware there's a kill story dropping this week on you? And if you hadn't have blown us up, we would not have been in such a bad place. Again, that's not an admission of guilt to anything. It says, if you had not blown us up, we would not be in such a bad place. So obviously she's venting to Melissa Nathan about stuff that's going on at work. That's not an admission of guilt as to what Stephanie Jones is saying here. But good try, I guess. And this is from Katie Warren. It says, story is up. Thanks again for your help. And that was... So this was August 14th. This was August 15th. Okay. So I can see how that would look bad, but you have to make the connection there. Make the connection. Okay. She also admits that she entered into the 2021 employment agreement and worked under its terms, including reaping all the benefits it provided her for more than 3 years. Okay. Hey, Zach, what's going on? And thank you, mods, for being here, by the way. Don't forget she isn't allowed to gift information from a subpoena to someone else. Precisely. That's kind of the issue here. It's like, they're pointing to the subpoena like, look, we got this subpoena. This happened legally. Nothing weird happened here. Okay, but the weird stuff happened before the subpoena was issued. And that is not something that's being disproven here at all. So, somebody says E for effort. E for effort, precisely. God, I want coffee. Okay, sorry. Okay. Having accepted an executive position of partner with JonesWorks, and the compensation and benefits that went along with it, Abel cannot now avoid the obligations she agreed to in exchange, which included the reasonable and ordinary obligations to not steal or disclose JonesWorks' confidential information and not poach JonesWorks employees and clients. Okay, pretty standard. Lacking any conceivable defense to her brazen violations of these obligations and of her duties of loyalty to JonesWorks, Abel now seeks to argue that those obligations do not bind her. But they do. Having agreed to and obtained the benefits of her contract with her New York employer under New York law, and after flagrantly breaching it, Abel cannot renege on that agreement because she now seeks strategic advances in doing so. Okay. And when it gets to this kind of stuff, the really case heavy stuff, the case citation heavy stuff, I'm going to leave that to the lawyers. Like I said, we're not going to read this word for word entirely across the board, but we'll go through most of it together. As far as like her, Jennifer Abel poaching clients and stuff like that, I mean, some of that stuff in Stephanie Jones' complaint, it looks pretty bad. I'll say that. It looks bad. She might have a case there. But I'm not an attorney, so keep that in mind. But it does look like she might have a case. As much as I hate to say that, and I don't want that to be true, yeah, she took some wrong steps there, it seems like. Okay. The smorgasbord of torts that Abel alleges also fail on their face. Not only does New York not even recognize the privacy-based torts Abel tries to allege, but no court has supported the theory that Abel advances, that she somehow had a legally recognized reasonable expectation of privacy against her employer in communications made on a company-owned phone. Simply put, Abel had no right to privately use her company phone to undermine and hide things from her employer, conduct a secret business for her own benefit against her employer's interests, and seek to harm her employer's public reputation and private business interests. Again, this is where she may have gone wrong. Obviously I can't say 100%, but some of the stuff in the initial complaint, if you haven't read it yet, I would encourage you to do so. Some of the stuff looks pretty bad. And there's been a lot of talk back and forth about the company-owned device and what you can and can't do with it and what your employer can and can't do with it. And the truth is, it's not really like, to a layperson, unless you're an attorney, it's really not black and white. Like, you can't just Google search it. I know lots of people like to use AI for some reason. AI can be a useful tool, but I wouldn't take legal advice from it. So, just saying, this is where it's going to get complicated, I think. And JonesWorks did nothing wrong in retrieving that phone when it fired Abel and reviewing and producing its contents in response to legal process, which revealed, in Abel's own words, in black and white, in text after text, the clear evidence of outrageous misconduct that Abel now stands accused of. For the same reason, Abel's false light claims similarly cannot stick. She may wish the world did not know about her unethical and unlawful acts, but the light that Abel has been cast in is unavoidably true. Okay. The remainder of Abel's claims are equally infirm. Abel does not actually identify any specific acts that allegedly distressed her and could plausibly meet the extraordinarily high bar required to sustain a claim for infliction of emotional distress. Her promissory fraud claim, too, relies on impermissibly amorphous allegations of harm, and also requires time travel, asserting that when Abel transferred her phone number to JonesWorks in 2020, she relied on alleged promises made in 2024. Abel's false imprisonment claim also collapses under its own weight, and for good reason. A meeting with an employment lawyer in an office conference room to be terminated for stealing confidential documents could not be false imprisonment. Having been finally called to account for her actions and having no viable defense, Abel has turned to defense by smokescreen. None of her counterclaims have legal merit, and the court should dismiss them and her corresponding affirmative defenses, in their entirety. Wow. Hey, Leah. I feel like the phone waters are so muddy since it was her personal number ported into it. Yeah, I mean, it just... basically, let's put it this way. Whether or not the law says Stephanie Jones could, like, go through all that stuff and do what she did, it feels icky because I feel like when I'm reading that, at least, I'm thinking, oh God, what if my employer ever violated my privacy like that? But it was their device, and she did enter into that, job knowing that it was a company-owned device. So it's just kind of like, it does feel a little like it's almost like I'm on the fence there, right? Like, it's like, hey, you shouldn't have done that. And also, hey, they shouldn't have done that. So it's just... But as far as that's how I feel as far as, like, the stuff about Justin and how that refers to, like, the Wayfarer parties and all that stuff. As far as her emails and texts and stuff, like, regarding her accessing things after they had already terminated, like, her account, and as far as her, like, talking about taking clients and stuff like that, yikes. That's where I'm like, oh, you're on your own with that one. I'm not even going to try to defend that. So... Okay. Their claim she was stealing company property, they have yet to prove it. They do actually, in Stephanie Jones' lawsuit, show emails where she says that she was accessing that stuff after she got locked out. And I'm, paraphrasing, so that may not be exactly what was said, but it looks pretty bad. It looks pretty bad. I'm just saying that. Like, it might not be exactly what I think when I look at it, so, like, let the lawyers look at it, but it looks bad on first glance to a layperson. So, okay. Having been finally called to account for her actions and having no viable defense, Abel has turned to defense by smokescreen. None of her counterclaims have legal merit, and the court should dismiss them and her corresponding affirmative defenses in their entirety. And I don't think that none of her claims have legal merit. No, I don't think that. But again, that's just me. Factual background, and remember, guys, I will do a quick recap of this. So, like, I'll go through a lot of it with you guys, and I'll also do a quick recap later. So if you have to hop out, that's fine. I understand, because not everybody can stick with me for as long as these streams are. Okay. I'm going to skim through this part because we know these parties. And this document is just pertaining to Stephanie Jones and Jen Abel, right? So this is a 30-page document, or 34 pages, and then we have over here the one against Wayfarer. So this is not going to talk a lot about some of the stuff we're going to ask about. We'll get to that one. Don't worry. Okay. They're talking about how she renegotiated the terms of her employment. Jen Abel did in 2021. This agreement expressly superseded all prior understandings, agreements, or representations by or among Jonesworks and Abel, including the offer letter and non-disclosure agreement she signed when first joining the company. Gotcha. Okay. Although still legally an employee, she was referred to as a partner and compensated as such. Abel received the benefits of a partner without the burden of buying equity or taking on partnership risk. Through the contract, Abel willingly agreed that any disputes she might have with Jonesworks, the New York-based company which she had joined, would be decided under New York law. Abel also agreed to entirely routine terms commensurate with her elevated position, including that she not steal or divulge the company's trade secrets. not compete with JonesWorks while working for the company for 6 months after leaving, and not try to poach JonesWorks clients or employees. Abel expressly agreed that these covenants were reasonable, including their time limits and geographic scope. Okay, and so we have footnote 1 here, which says, although Abel selectively and misleadingly quotes excerpts from her 2021 employment agreement in her counterclaims, by referencing that agreement, she incorporated it into her counterclaims, and the court can thus consider it in its entirety. Okay. I'm going to see dueling complaints between these people with the word histrionic in it. And the way that people use the word histrionic online, like I've seen it become more popular in the last couple years or so, is very incorrect. But like I said, I work in psych. I'm not a lawyer. So, of course, that's going to annoy me. But that's something we'll talk about another time if anybody wants to talk about that. The way that people describe some of these things in their complaints, I'm just kind of like, guys, that's so dramatic. Stop. Okay. Abel's counterclaims are laden with histrionic complaints about all aspects of her employment at JonesWorks. I understand that histrionic is a word that makes you feel like that sentence is going to be more powerful, but it actually just sounds stupid and out of place there. Okay. There was nothing histrionic about that court document. You might not have liked it. It might have invoked some emotions in you, but there was nothing histrionic about that document. No, it's just a disagreement, or a very obviously complicated and large disagreement, but it wasn't like overly emotional and shit like that, you know? You could argue that some of it was rude, but hello, this is a court battle. They're not like trying to kumbaya. Okay. It's 7:30 in the morning. I'm doing my best to express myself here. Not only is this irrelevant, it is unsupported by reality. Again, y'all are so dramatic. I mean, come on. Abel worked at the company for more than 4 years, never voicing any of the concerns that she now pleads in the new version of revisionist history that populates her counterclaims. Abel devotes paragraphs to wholly unsupported character assassination and baseless personal insults against Jones. Wow. I feel like we're maybe fighting fire with fire here, to be honest. So let's not pretend that both sides aren't doing that. None of which excuses her conduct or supports her claims, and which is also flatly contradicted by the communications that she herself cites in support, writing to Jones around the time of her prospective departure. And then they're citing her complaint here, or the counterclaims here. It says, with all of this said, the facts remain. I respect you immensely, and I guess this is like a message that she included in paragraph 65. I feel so grateful for the opportunities you have given me with your premier clients and how you have lifted me up as your partner. I would not have had the opportunity to be in many of the rooms that I have been in without you opening the door. This company you have built is exceptional, and I hold our teams with the highest regard. I know I didn't do it by myself, but I do take pride in what I've contributed to your LA office and the team I've been building and managing over the past 4 years, along with the new clients and opportunities I have procured. So to me, that just seems like something you say to your employer when you're leaving and you want to be polite and you want to try to keep good relationships, you know? So it sounds like she was actually tiptoeing around trying not to set Stephanie Jones off because Stephanie Jones had apparently been a ticking time bomb, which I can't confirm that. I wasn't there, but that's their narrative, right? So that's what they're saying. And so she's trying to kind of delicately handle her departure so as to not start this war that we're now seeing. So that's not, again, not the flex that you think it is. I'm going to just say that. Okay. In July 2024, Abel informed Jones of her intent to leave JonesWorks. At first, the planned departure was amicable. Okay. They arranged for her transition, and Abel made logistical arrangements for departure, including asking that her phone number be released. But in mid-August, they learned after inquiring into suspicious file transfers on its computer systems that Abel had been downloading dozens of proprietary documents from the company's systems to her personal laptop, which she had no reason or authorization to access, let alone surreptitiously misappropriate. JonesWorks swiftly responded and, on August 21st, with counsel, terminated Abel. Okay. To terminate Abel, JonesWorks took the common and reasonable step of requesting that Abel meet with its counsel and chief of staff, asked to review the personal laptop that she'd been using for company business, which she agreed to in writing, and asked her to sign termination forms, which she did, including falsely signing a statement that she had not retained any JonesWorks documents, despite plain forensic evidence proving that she had been emailing documents to herself weeks before her termination. So again, that's where I'm saying, like, it's pretty bad. It looks pretty bad for her. And it's going to come down to, like, can you prove she actually did what you're saying she did, obviously. And then also, this doesn't explain, and I don't know if they're going to explain down here, this does not explain why they refused to release her phone number when they told her they were going to. So I don't know what the deal is there. Obviously, to me, it seems like the truth is somewhere in the middle of all these things. But that doesn't mean that Stephanie Jones didn't do anything wrong. I'm pretty sure she did. So, yeah, this is just very dramatic. The Publicis lawsuit is like, you could make like a drama movie out of this. Like, somebody should. It's pretty crazy. Okay. Abel's allegations that employment paperwork made her dissociate and that a security guard was blocking the exit are as incoherent as they are fantastical. No one told her she could not leave because she didn't ask. No one ever prevented her from leaving because she didn't try. And no one engaged in anything but professional conduct, and Abel does not allege otherwise. Indeed, Abel admits that the security guard was not even present in the room during her termination meeting. Abel admits she walked into a conference room where no security guard was present, had a brief meeting with office personnel and counsel, signed paperwork, returned her company phone, and left. Okay. Continuing its inquiry into the proprietary documents that Abel had stolen, JonesWorks reviewed the phone and found messages revealing Abel spearheading a campaign to retaliate against Lively for her allegations of sexual harassment against Baldoni, an instigation of a campaign of destruction and defamation against Jones herself. Abel alleges that JonesWorks' review and ultimate revelation of the text messages was unlawful and invaded her privacy, including that Lively's publicist allegedly saw text from Abel's phone and that her personal information was disclosed. Okay. Yet this is contradicted by Abel's admission that the texts were contained on a company-owned phone that she voluntarily relinquished on her termination as required. And by the fact that the text messages that have been publicly revealed through these legal filings were produced pursuant to a lawfully executed subpoena. See complete docket 1, Lively versus Wayfarer Studios. Okay, so they're just citing Blake's complaint. I mean, I don't really think that that's a reliable source of information, so I'm not even going to look at that. So, and I'm kidding, I have looked at it many times, but these claims, again, it really does seem like she did like show it to Lively's publicist the second that she kicked Abel out. Because then Lively's publicist texted, I want to say it was Melissa Nathan, been like, I've seen your messages, or I know what you did, or whatever, and you're going down. And they didn't say it like that. I'm making that up. I'm paraphrasing. Okay. But that's what reportedly happened. And this does nothing to combat that argument, in my opinion. So it doesn't matter if you had a lawfully executed subpoena if you got it after you broke the law. Wayfarer was still her client, at that point. So when Abel left. So if she looked at that stuff right away and then is like, hey, Blake, hey, Leslie, look at this, you know? And at that point, it's like Sloane really stuck her foot in it because she shouldn't have texted him and like, I've seen what you did. I know what you did last summer, All right. They're still not telling us who issued the subpoena or providing a copy. Apparently, they're leaking it to news outlets now. So, and I guess they're allowed to do that. I don't know. But I haven't seen it, and I'll believe it when I see it. So, actually, I mean, I do believe there was a subpoena. I just think it was issued, like I said, after the crime was committed or after the conspiracy was committed. Like, it's like that doesn't mean anything. Doesn't mean jack shit. All right. Hey, man, it's early. Give me a second. Hey, thank you for the 5. Laura, did you pull an all-nighter or something? Yes, kind of. No, I don't know. Damn, I'm worse. I saw your last live ended 1 hour ago. Been sipping. Now you're live again. Yeah, I was on until like 1 a.m. last night almost. Thank you for the 5 again. Hear me out. I'm also awake because my wife told me that she and the boys are leaving and they are packing stuff in their cars while I don't stop them. Huh. Okay. Hear me out. Thank you for the 5. Full disclosure, might have given the wrong impression. There's a high school band festival in Eastern Washington. They'll be back Sunday night. Sorry. Yeah. You should lead with that. All right. Thanks, man. All right. Let me get back to reading this because I'm not trying to make everybody sit here and listen to me talk forever. So. All right. Continuing its inquiry into the proprietary documents that Abel had stolen, Jonesworks reviewed the phone and found messages revealing Abel spearheading a campaign to retaliate against Lively for her allegations. Yeah, we've been through that. That's stupid as fuck. That's not what happened. Abel alleges that Jonesworks' review and ultimate revelation of the text messages was unlawful and invaded her privacy, including that Lively's publicist allegedly saw text from Abel's phone and that her personal information was disclosed. Okay. We saw the subpoena thing. All right. And now we have legal standard, which is where I'm going to start to skim a lot. 1. Abel's California statutory claims and defenses must be dismissed because Abel agreed that New York law would govern these disputes. Okay. And when it comes to the employment agreement, contract type stuff, that's where I'm like, yeah, I'm leaving that to Albertson and Davidson. I'm leaving that to Omar. I can give you comments as far as like what I think about the evidence that's been presented, but when it comes to like the case law stuff, we got better people to tell you about that. All right. A, the New York choice of law clause is valid and enforceable. Good for you, honey. Okay. Here, the New York choice of law clause in Abel's 2021 employment agreement is plainly valid and enforceable, as New York has plentiful contacts with Abel's employment and this dispute. All right. Abel could not avail herself of this forum when it suits her, yet seek to eschew its law when it does not. All right. Abel's own conduct and allegations in this case demonstrate amply sufficient New York contacts to enforce her contractual choice of law clause. This holds true despite the fact that Abel alleges that she resided in California during her employment and performed some of her work in California. Okay. As this court has recognized and as New York's overriding deference to contractual choice of law clauses underscores, where more than one jurisdiction might have an interest in the dispute, the party's freedom to choose the governing law should be honored and that contractual choice upheld. So this is all jurisdictional stuff that I'm like, yawn. Put me back to sleep, please. Not like forever, just until this afternoon or something. Okay. B, New York law requires dismissal of Abel's counterclaims 1 through 5. Okay, we're going to skim over that. Okay. We have a footnote here that looks kind of interesting. Let me see if I can find where it's supposed to be. There we go. Okay. As explained above, New York law mandates the enforcement of the contractual choice of law and forum selection provisions. California law, which may call for the voiding of those provisions in certain circumstances, does not apply here. Okay. Ice Roll Landing, thank you for the 2. I appreciate you. All right. The footnote says Abel's self-help attempt to unilaterally void the clause has no legal effect on its validity. This tactic is transparently pretextual and unavailing under both New York and California law. Okay. 2. Abel's tort claims must be dismissed. The 2021 Employment Agreement's choice of law clause broadly calls for the application of New York law to the parties' performance of their roles and the relationship between JonesWorks and Abel. As such, New York law applies to Abel's remaining grab bag of tort claims, which uniformly fail. It would also fail even if California law were held to apply. Okay. A. Abel cannot claim that her employer looking at work text on a work phone invaded her privacy. And that's where he gets to, like, was that actually a work text or was that a personal text? I think you could argue, I guess, from a, and this is, again, just from a spectator standpoint, not a lawyer standpoint, you could argue if you're, like, talking amongst other people, like, hey, like, if they're talking about their clients, if she's talking to Melissa Nathan about their clients, then it kind of seems like that would be a work text. But then some other people would say, no, that's like two friends talking back and forth to each other. So we'll have to ask the 2 lawyers about that. Okay. Abel's invasion of privacy claims, counterclaims 6 and 7, fail on their face. New York does not recognize common law privacy tort claims, including specifically the 2 claims Abel brings here. Intrusion upon seclusion, that rhymes, and false light. It's fine, I'm an adult, I swear. Okay, talking about California versus New York law again. First, Abel admits she voluntarily transferred her personal phone number to JonesWorks upon hiring, and that her newly issued device with that phone number was a company-owned and controlled iPhone. As a matter of well-settled law, Abel enjoyed no reasonable expectation of privacy in that JonesWorks phone. So, yeah. Lots of, obviously, debate about that kind of stuff on social media, on Reddit, and news articles. I mean, a lot of these websites that are putting this stuff out is like, I've now seen the way that they work, and I'm appalled by it. So let's put it that way. Okay. Abel's conclusory allegation that she had a reasonable expectation of privacy such that the contents of her personal cell phone would remain private is of no moment. Because 1, courts rightfully reject such legal conclusions masquerading as factual allegations. And 2, Abel's bald allegations that the phone at issue was personal is incomprehensible in light of her admissions that the phone was owned by and returned to JonesWorks. Because both of Abel's invasion of privacy claims relate exclusively to the contents of a company-owned phone, in which she enjoyed no reasonable expectation of privacy, her claims fail. Second, even if Abel had a privacy interest in her company's phone, which she plainly does not, well, I wouldn't say it's that plainly, but maybe to legal people, but okay. She fails to allege that JonesWorks acted in a way that was a highly offensive invasion of that privacy. I don't think she fails to allege that at all. Or an egregious breach of social norms. Again, were we reading the same document? At best, Abel alleges generally that her employer reviewed the contents of work communications sent on a company phone and disclosed those contents. But these text messages were produced pursuant to lawful subpoena, and California courts are clear that employer compliance with a legal subpoena is privileged and cannot constitute an invasion of privacy. Okay, but again, okay, I guess they're going to address what I'm about to say, so I'm not going to. It says, even the single inflammatory yet barren allegation that Abel's private information was leaked, based apparently on third and fourth hand information. Counterclaims 92 and 98, let's see, alleges at most that Abel's employer made some disclosures regarding an illegal harassment and retaliation campaign undertaken during Abel's employment on her work phone to the targets of that harassment. So we're not even denying it here. Okay. So basically they're saying, yeah, that even if that happened, it alleges at most that this happened, but even if that happened, whatever. This too does not rise to the level of highly offensive or egregious that would meet the standard. Oh man. Wow. That's bad. I mean, even if they're arguing here that this doesn't meet the standard for what she's claiming, but even if it doesn't meet that the legal standard for what she's claiming here, if they did that, which it certainly seems to be what happened, if they did that, they literally did, light the fuse that blew all this up. So wow. So at the very least, Stephanie Jones is not someone that I would want to work with if, I were a potential client. Jesus. Third, Abel's false light claims fails for the additional and independent reasons that she does not allege any false or misleading disclosures. Okay. Oh, good Lord. No, you're kidding me. Oh, I'm sorry. Oh, I was just looking at the footnote and it made me mad. As detailed in Jonesworks' motion to dismiss the separate counterclaims brought by Abel's co-defendant, Wayfarer Studios, any such disclosure would also be protected by the recently passed Federal Speak Out Act, through which Congress has confirmed that there was a strong public policy in favor of encouraging and protecting the disclosure of information related to sexual harassment. Any disclosure in furtherance of such public policy cannot possibly be considered highly offensive. Are you kidding? That's not what happened here. You guys suck. Jesus Christ. This is bizarre. Okay. The thrust of Abel's real complaint appears to be not that Jones said anything false about her, but that Jonesworks revealed Abel's own words to the public. Far from portraying her in a false light, the publication of her own text messages in her own words has painted her in the truth. Her privacy counterclaims should be dismissed. Show us your text then. I mean, damn. No, they're saying there is a subpoena. But the thing is, this disclosure, which they're technically not saying, yeah, we did that, but come on, that's what they're saying. This disclosure happened before the subpoena, which is like, then who gives a fuck if you had a subpoena? You obviously did the damage well before that even matters. So the answer is both yes and no. Like, yes, there was a subpoena, but no, the subpoena is not really how they got the text messages, So it depends on how you want to look at it. Personally, I think that what they did was they skirted the law on that one. And now they're going to try to use the Speak Out Act to excuse those actions. So obviously, it seems like Stephanie Jones certainly framed things in a way that made it look like they were going after Blake Lively, which is interesting when you think back again to that text message that she used in her complaint to allege a smear campaign against her, Stephanie Jones, was one of the same text messages that Blake Lively used in her complaint to allege there was a smear campaign against her. So, yeah. All right. Abel's distress, if any, arises from being caught red-handed and does not give rise to tort claims. Abel's claims sounding an infliction of emotional distress also fail. To allege intentional infliction of emotional distress, Abel must allege 1, extreme and outrageous conduct, 2, intent to cause or reckless disregard of the probability of causing severe emotional distress, okay, 3, a casual connection, and 4, severe emotional distress. Okay. Skim over that. 1, Abel fails to allege legally cognizable severe emotional distress. Well, that doesn't seem true, but okay. Abel's emotional distress claim fail at the outset because she neglects to plead any sufficient severe emotional distress. Okay. Abel's rambling allegations, albeit hyperbolic, cannot meet this standard. She complains of certain alleged working conditions at Jones Works, including Jones calling at late hours and reprimanding Abel in front of other employees. Despite conceding that she remained working there for more than 4 years, and wrote to Jones ahead of her departure that I respect you immensely, I feel so grateful for the opportunities, and we read that message above, so. Okay. This is just kind of rehashing what Jen Abel wrote, or not Jen Abel wrote, but Jen Abel's lawyers wrote. And she complains of the inconvenience of losing access to her mobile phone number. I mean, that's understating it quite a bit there, Stephanie. But okay. Didn't she have stuff on that phone relating to, or stuff tied to that phone number relating to, like, her father or something like that? Somebody correct me if I'm wrong. But at the very least, I'm pretty sure she had stuff, like family stuff, tied to that number, and she needed it. So they're citing a case here, Hughes v. Pear, where it says, worry, anxiety, upset stomach, concern, and agitation do not constitute severe emotional distress. Well, that's not all they were saying she had, you know what I mean? Her wholly conclusory allegations that she suffered severe or extreme emotional distress and mental anguish cannot save the failure to specifically plead such distress. These claims must be dismissed on this basis alone. 2, Abel alleges no extreme or outrageous conduct. Well, that's not true, but okay. Right. Abel does not allege any such extreme and outrageous conduct that would be sufficient to meet the required threshold to sustain her claims. Indeed, she does not even allege any specific identifiable conduct in support of this claim at all. I mean, you can put it in bold, but it still doesn't seem to be true in my opinion, but alright. Instead, she only vaguely invokes the misconduct of Jones and Jones Works and its officers, directors, employees, and agents. Okay. Apart from this, even the supposed misconduct by Jones and Jones Works that Abel does allege does not approach the required threshold. Her allegations at most describe her discomfort with Jones' management style. Okay. Under which Abel worked for 4 years, taking on ever increasing responsibility and reaping the commensurate awards. The law affirmatively excludes much of this complained of conduct from forming the basis for emotional distress claims. Okay. 3, Abel's negligence-based claim fails because she alleges no negligence nor specific breach of duty. Okay. So she alleges Jones and Jones Works intended to cause Abel emotional distress. That's what they're talking about there. And footnote 6 says, Abel does nothing more than sling baseless and disparaging allegations about Jones' sleep schedule, attacking Jones' vindicated concern about Abel stealing clients, and magically transforming a tarot card reader at a Jones Works office party into an alleged psychic. Again, I'm going to say the truth is somewhere in the middle in regards to the psychic thing. It could possibly, they could have exaggerated that. Sure. It could be exaggerated. And her recollection of that could even just be exaggerated. but also Stephanie Jones sounds a little crazy. So I'm not positive. As far as like a tarot card reading, that's not really my thing. I don't really I don't feel the need to like knock anybody who, believes in that or likes to do that, because I think everybody should be able to do what they want. And frankly, my saying it's not my thing just means like I don't know anything about it. So I'm not trying to say anything bad about anybody, but the allegations were far worse than having a tarot card reader at an office party, right? So the allegations were that she was like wildly inappropriate regarding like, I want to say it was like, I can't remember if it was like fertility, pregnancy, something like that, regarding one of the employees. But when I do a recap, I'll go back over it. But yeah. Okay. Abel's fraud claim fails in every possible way. First, she fails to state with particularity the circumstances constituting fraud. Her vague allegation that Jones and Jonesworks promised Abel that, notwithstanding her use of the phone, the company phone, Abel would retain possession of the actual phone number. Okay. Second, to the extent the counterclaims may be read to allege any specific statements, Abel's claimed reliance on those statements is facially implausible. Okay. Her fraud cause of action is silent as to what Abel allegedly did in reliance on this promise. But even giving the counterclaims yet another benefit of the doubt, Abel insinuates, but does not actually allege, that she transferred her phone number to the Jonesworks phone based on these promises. But that transfer took place in 2020, 4 years before the only alleged fraudulent promises, a facially implausible allegation that cannot stand. I don't know about that. Third, Abel must, but has not, set out specific facts in her complaint demonstrating that defendants never intended to make good on any of the promises made. Okay. Such vague conclusions are patently insufficient. What are they referring to there? Oh, that they never intended to perform the promise? Okay. D, sitting across a conference table from an attorney to be terminated for misconduct is not false imprisonment. Abel's sole reference to restraints on her movement is that a physically imposing security guard was standing just outside, never inside, of the conference room where the group spoke, and was allegedly but wholly non-specifically blocking the exit. Abel does not allege, as she must, that she asked to leave or that she was told she could not leave. She does not allege that she attempted to leave or that anyone stopped her or that anyone ever touched her. Abel merely asserts the legal conclusion without any supporting facts that Jonesworks deprived Abel of freedom of movement by use of physical barrier, force, threat of force, menace, and or unreasonable duress. Okay. This claim also fails independently under its second and third elements because Abel had stolen confidential documents, and this imminent threat to company property justifies Jonesworks' actions. And this is, they're citing a case here that says, merchants who detain individuals whom they have probable cause to believe are about to injure their property are privileged against a false imprisonment action, so long as the detention is carried out for a reasonable time and in a reasonable manner. So those things are important, right? And I don't know if we have that here, so I can't really say whether or not that's going to stand up. All right, conclusion. For the foregoing reasons, plaintiffs respectfully request that the court dismiss Abel's counterclaim in their entirety with prejudice. All right. So we have this one against Wayfarer, which is 28 pages. Here's what I'm going to do. It's 8 o'clock right now. Okay, so I'm going to take a break, and I'm going to come back and read this one against Wayfarer, because I need like 30 minutes or so. Since I literally just rolled out of bed and came up here and did this. I have a lot to get through before I start work today. I'll probably start work late so I can finish all this. Hi, Lauren, do you ever sleep? I slept for like 4 or 5 hours, I think. So We're good. Trust me, I'm gonna sleep in tomorrow. It's gonna be good. Okay. Yeah, so I'll be back. Let's say 9 o'clock. How about that? Okay. They're just making things up. I mean, I think it's somewhere in the middle. I don't think that a lot of what they found is. I think they're mischaracterizing a lot of what they found, but it sounds like they did find some stuff there. And if you read the original complaint, there are some references to specific emails and stuff like that. I don't. What I don't want to do is write it off as like you're making it up. You know what I mean? Because I want to be fair and like say I need to look at both sides. I don't just want to automatically be like, well, you're a bitch, so I don't believe what you're saying. Again, I believe that she broke the law. I believe that she, did a whole bunch of stuff that was wrong. But I'm not saying that there wasn't any wrong on Jennifer Abel's side because it kind of seems like there might be. But that's just me. That's just my opinion. So don't fight me because I won't respond. Just don't fight me, okay? You can disagree with me respectfully, but don't like call me names and stuff like that because I know people like to do that in the comments. So, all right, I'll see you guys again in a little less than an hour. Thank you for joining me, and yeah, I'm gonna have a lot out for you today. So, bye. I will fight you. Don't fight me. Oh, also, Georgie, thank you for the 5. Happy to see the gummy is worn off. Not as happy as I am. All right, bye.